This literally has to be the unluckiest recording ever, but let's do it. So we are going to talk about the Teresa Falaran versus Milwaukee Board of Public and Schools interference and First Amendment suppression by the Department of Workforce Development. What do I mean by that? The Department of Workforce Development refused to accept Teresa Falaran's withdrawal because Teresa Falaran said that she was withdrawing her complaint in protest because of the actions of Maria Seltzer and Laura Amundsen. And the state employee who straight up put it in writing said it has to be voluntary. Yours truly talked to the state employee and informed them of the law. Pretty simple. 218.03 sub 7, what does it say? It says that a request to withdraw needs to be in writing and needs to be signed. Nothing but voluntary, to be perfectly clear. But this particular state employee insisted and determined that it had to be voluntary. Let's get into that. So, if you'll recall, this Teresa Falaran case was set for hearing for months and months and months and months. And for months and months and months and months, the judge in that case, that's Peter Reinhart, knew that Calvin Furman was going to be a witness. In fact, we sent special emails all about it. It was not until the morning of the Calvin Furman's committee to hire him for a permanent ALJ position that the judge decided that there was a problem, finally at last. And let's recall that Maria Seltzer asked Judge Reinhart to be on the panel. Judge Reinhart agreed to be on the panel and didn't say anything for at least a month. And again, not until the day of does the judge mention anything about this issue. 13 days ahead of the hearing. Witnesses are subpoenaed. Thousands of dollars are spent. Hundreds of hours spent preparing. And all poof gone because this judge decided to wait until the last minute for something he should have done 6 to 8 months ago that we asked him to do 6 to 8 months ago. It depends on how you look at it. I think we were crystal clear at the 6-month point. Okay. So let's also recall that Judge Reinhart received and emailed his supervisor, Maria Seltzer. This is also Calvin Furman's supervisor, Maria Seltzer. And Maria Seltzer got a draft from Reinhart because although Maria Seltzer will tell us, and so will many other people at the department, that the ALJs are the only ones, the administrative law judges are the only ones who make decisions about the hearings. We'll see what happens in reality. So they have discussions. We have the records of those discussions, but we don't have the recordings of those discussions. We know they happened. We don't know what was said. We then know that there's a bunch of emails back and forth about when can we discuss this, how can I give you a draft, and the judge Reinhart sends to Maria Seltzer his draft containing something like 2 paragraphs, basically saying judge has to recuse himself if there's a conflict. I believe there's a conflict. I'm recusing myself. He sends that in a sort of letterhead, all that, to Maria Seltzer, and he puts in the bottom there, and I'm paraphrasing with all of this, that he thinks that less is more, but let me know what you think. Okay? So she does a lot more than lets him know what she thinks. She writes several paragraphs that are additionally put in there, including she puts in that old the law that we all know and have discussed several times about bias and presumption and everything, which I don't think is quite accurate anymore, but we'll leave that aside. Okay. So she puts in a paragraph about how the Judge Reinhart thinks that Calvin Furman is honest and of good character, something along those lines. Again, I'm paraphrasing. That we don't, nobody tells us that she writes that. We find that out for ourselves. That judge then recuses himself. I send a bunch of questions to them. They say something like Ben's whining and complaining about what's going on. They then assign it to Laura Amundsen, and we're going to get back to her. But she simply there's just a note in the file that says that Amundsen contacted Celsor and told her that she wasn't going to do in-person hearings. Okay. Then every single ALJ goes down the list, except for Calvin Furman and Gelhard, because Gelhard and I don't work with each other anymore. Those two, all the rest of the judges go through the list. Now, at that point, Maria Celsor emails Ramona Natera and says there are no more judges left. Of course, leaving aside the fact that Calvin Furman probably can't be the judge when he's his own witness. I mean, even that would be too much. John Gelhard, of course, never recused himself in that case. I asked her upon what rule they had that said that he could just permanently recuse himself from me, but she said that they could do that if they wanted to. And I said, all right, I'll keep that in mind for future reference or something to that effect. So then at some point, we get a email from, we're waiting here. I'm pushing. What the heck's going on? You can't just do this. It's just, kind of outrageous because at this point, everything's just sitting there for like a month goes by and another month goes by. And Ramona Natera, this is Maria Celsor's boss, simply sends an email to her or something to her. They won't produce it. They haven't produced it to us saying that, saying to Maria Celsor, assign this case to Laura Amundsen. Okay? Again, Laura Amundsen already said she would not do this case because it had an in-person hearing. How she could do that, I don't know, but that's what happened. Okay? So, if the case is assigned to her, what does Laura Amundsen do? She immediately puts the case in abeyance and says that there's another case that's being investigated, which is true. Teresa Fowler on a retaliation complaint because the judge wouldn't consolidate them originally. So we filed a retaliation one, and the new judge comes in and says, no, I'm going to consolidate these cases. I've looked at everything. I don't know how she can look at an investigation. She has absolutely no right to do that. There's plenty of cases on that. She can receive other documents from the district, from the agency and the department. That is absolutely true. But if she does do that, then we get the chance to respond to that, and she has to tell us ahead of time before considering them. So we say, sorry, we refuse. We do not. There's only one thing that allows cases to be consolidated, and this doesn't apply. The judge responds back and says, I agree that the one statute that says that this doesn't apply, the consolidation doesn't apply here. I'm just doing this, and this one, judicial efficiency, we'll get this one. This was administrative efficiency. I wonder I wonder how many ALJs it comes to take. So keep in mind, I don't think there's any really such thing as administrative efficiency. Why? This is a really good question. Because there are powers of the ALJ, and in nowhere does it say you can do anything. We've read the 9 powers many times, and then it says anything in conformity with the rules of this statute or the rules of this in this statute. Okay, it doesn't say or anything that's expedient. That's just a naked power grab. And, of course, we responded on that. But ultimately, they just, what are you going to do, sue me? So our choice was to wait another, year possibly to have this thing get investigated. who knows? The main problem is it's really hard to have faith in the Department of Workforce Development when they're clearly doing what they will and what they can, and not what is follows the law. And this last story here, I think, is going to exemplify that more than anything, and it should make anyone, I don't care where you live, Australia or anyone else, anywhere else's blood boil. Um, on that subject, thank you, Ben. Great segue. You're welcome, Ben. No problem. There's been some comments here about, we don't know anything about hot here in Wisconsin. Try like Brisbane or something like that. I don't know what their 4th of July is equivalent. What the heck is the hottest day of the year? Like Boxing Day? I don't know. Man, when I see Australia on like video and I see the flora there, all I can say is I am very clear that's not the Americas or Asia. Other than that, I'm lost. Yeah, I definitely know enough about botany to feel intimidated about Australia. But okay. Um, do you guys have like -20? Even a little bit? I mean, that's probably, we would have to say this, wouldn't we? But I think I'm sure that in Wisconsin we feel that -20 is part of the. It's hard to have a correct soul without experiencing -20 from time to time. But we would have to say that, wouldn't we? It sure does make you think and clear out a place, doesn't it? Okay. So, I have a little bit of a back and forth. And it's like this. There's the investigator. I send them a form 624, something like that. I have a multimedia presentation, but I'm not going to do it because it has addresses all over it. I'm not getting this thing blocked for that. So we go through this with the investigator and back and forth because basically the investigator changes the form that we file because the form says, why are you withdrawing the complaint? And we put in there because of Maria Selsor and Laura Amundsen are illegally consolidating this case and delaying our day in court, and we should have had it 3 months ago. Something along those lines. So, possibly a bit cheeky, but also what they're doing is plainly outrageous, and they're just the attempts to delay the hearing are manifest and I think unacceptable. So at some point, one can be cheeky. One can. I think at almost any point, one can be cheeky. It'd almost be rash not to. So we get it. I get one of those see attached email, and I know her as a former investigator. I don't know her as a supervisor. I'm one of the many reasons why this recording has been delayed and happening here is because I did a whole one where I talked about her right after the thing from the clouds. And I don't think I said in fact, I'm quite positive I didn't say anything negative about her other than what I'm going to reveal. But again, she's at sort of a level that I feel it's a different story. I feel she's a worker. So we're going to leave her out. So, yeah, that I guess I should say we should, because I want to make clear that's a more of a collective. Yeah, that's how we feel. Okay, so I'm sorry for the delay. We get a letter here, and it says you cannot process the withdrawal, and we refuse to do it because it says it's under protest, all right, and that therefore it's not voluntary. Man, that's a bad paraphrase. And the funny thing about that was About 3 hours before that, we had sent a letter to Laura Amundsen and Maria Selsor saying, this case is withdrawn, because it was on the portal, and boy, do we have that screenshot. Thank goodness for screenshots. Shout out for the screenshots. Man, I've been watching too much Lead Attorney and need to watch YSL and need to start hitting some the ones and twos, as he would say. Okay. So she refuses to. What the heck? So what do we do? What does anybody do? I didn't call her up and record, but I did call her up. And yeah, again, there's a line. So some people are making policy, I think, and other people are not making policy. I think that is clear. But this person talked to me and for like 20, 25 minutes. And we went through, number one, identified that it was this person's feelings that a withdrawal had to be voluntary and couldn't be involuntary. And something like, well, you shouldn't be withdrawing because of, what Maria Seltzer and whatever. And I'm like, I think we can agree on that we should live in a world in which we don't have to withdraw our complaints because of the, at least what we say are bad actions of the supervisor of the administrative law judges and the last one to hold the hot potato. Let's not forget how many times we asked Matt White for the determination and the decision on the termination for Jose Garcia Joven's case, and the day it came was supposed to be on the last day of the hearing. And they were extremely flummoxed, and by the way, did refuse to consolidate. We've all seen that. Refused. So I read out to this person 218.03.7, and we go through the rules. Okay? And she says, well, I still think that it has to be voluntary. And I'm like, but seriously, this is a criminal law. You got to show me something other than your feelings of why this should be the case. Okay? And, people who keep asking me about Chevron rule and, the change in there and everything else, I can say this, okay? There's no doubt about it that a lot of this attack on the administrative state is an attack on environmental regulation, okay? I am absolutely for protection of environment. I want to be clear about that. So I'm not, I think that I want to disassociate myself from that group, okay? But I do also see the problem in this sort of wild swings between, for example, Trump-era policy or Biden-era policy or whatever. Now, at the same time, the president is supposed to be the chief bureaucrat, but it's the way that they sort of interpret these rules, and then we're stuck with them for 3 years and possibly one more into the next president, and then they all get changed again. That seems to me to be counterproductive, and there needs to be some, because and what the point of what everybody's saying is, it's ultimately an absence of legislation. And whatever you think about, bureaucrats, they're not elected. And whatever you think about wacko, I'm not going to say Republicans. I'm going to say wacko, what's the word for the bottom legislature? Representatives. Wacko representatives, because we have plenty, or how about moronic or whatever, they're all representatives, which is at least more democratic than a bureaucrat. With me? Okay. So we go through, and I guess we're lucky it's a couple days later because you're not getting the hot version. Uh, we go through quite a bit. But in the end, it comes down to this. I asked her, and this is confirmed by email, so I don't think we have a problem. This, of course, they sort of excise that. I'm on 3 different screenshots that contain 3 different information and 3 different versions right now of how this withdrawal happened in the portal. But we keep checking. So, I mean, you have to just sort of wonder who it benefits to play this kind of game. Is it and why are they spending all of our money playing games on us, and don't they have other and better things to do? So again, when we're talking, and this is very superficially here because I think there's a lot of nuance and a lot more on administrative law than that. But ultimately, my feelings on administrative law would be completely different. There's absolutely no doubt. And I would probably be more in favor of sort of Chevron deference than I am now. And the reason is simply this. The people who are in place there, and now remember, the Wisconsin Department of Workforce Development has undergone several different purges, and there's a lot of reasons that the people who are there are the people that are there. But whatever those reasons, the people that are there are not democratically elected. They're not democratically accountable. And in fact, they spend a lot of taxpayer money keeping themselves from being democratically accountable. So I went over with this person and said 2 things. Can I file it if I have the words under protest? No, can't do that. Okay. Can I file it if I have the word Maria Seltzer in there? No, can't do that. She doesn't think it's appropriate to name state employees in a withdrawal complaint. It's just a form. You know what else she said? She told me it was not an arena. And I told her I've heard that from several other people at the department before. And that word arena really troubled me. I mean, I'm glad she didn't say this is not a YouTube channel. That would be something. But, another way to put it is this is not a public forum. And that, I think, is precisely where she's wrong. And luckily, we got to go. So we sent it right up the chain to the secretary. We sent it to Ramona Natera. We sent it to, I think, Maria Seltzer, just for copying purposes, Matt White. Maybe not Maria Seltzer at all. This person's boss is Matt White. I sent them the law. Remember, it needs to be in writing, needs to be signed. I explained to them that they refused to do it. I sent them a screenshot of their refusal, how they had already withdrawn the complaint, and then this person had unwithdrawn the complaint, if you can possibly imagine such a thing. And then, I get an email back from Ramona Natera saying, your complaint will be withdrawn with prejudice. Which, again, they didn't have to do it with prejudice, but they chose to. That's their sort of kick in the pants. That means that we are not allowed to refile that complaint, which in here technically means nothing, and as I'll explain at some other point in time. But it was sort of we'll do it, nanny, which, thanks for following the rules, I guess. And that I would say I could not resist to put a mention to the demise of the Chevron rule, because I think that it's this behavior, this kind of we'll do whatever we want until you catches red-handed. Now, let's keep in mind, it's my opinion here that my client's First Amendment rights were violated and that she suffered at least 2 days of deprivation here by, I think it's now 3, of having the complaint unwithdrawn. You know, that might not be the end of the world. To some, it might be the principle of the thing. Then you can say, hey, it's moot, they put it back. Well, does she have damages? What is the worth to have your complaint continue to be held up for another couple of days? Is it worth something? I think that's a big question. Nevertheless, it's absolutely chills your free speech. So we continued, we put a reference to the First Amendment, but we also, and I think this is important to remember, your state has its own constitution. And it's oftentimes an important source of language that really is, better than the federal Constitution. And the way we can look at it here is the federal Constitution is the floor, but your state Constitution may be the ceiling. So you're definitely going to want to check it out. And ours is pretty good. It has a lot of, no libel for free speech, and not without a jury. So that's kind of cool. But yeah, so at the end, I guess cooler heads prevailed for once in a great blue. I mean, for the first time ever, I could say in the history of the Teresa Faleron case, the Department of Work, and also in the history of the Department of Work, MPS, Ben Hitchcock Cross and Company bring their MPS complaints to the Department of Workforce Development, that the Department of Workforce Development did not double down. So possibly that's something. But I think that there's probably going to have to be a little bit more enforcement to get things like this from ever happening again. Because, again, it's completely unacceptable for an investigator or their supervisor to invent the law. It's not okay when they do it. It's not okay when Maria Seltzer does it for administrative efficiency. It's not okay. And so that's when we have a rules-based system, everybody needs to follow the rules. So that's my thoughts about that. What do you think? Hopefully this is a button that does something. I'm afraid it's totally the wrong one, but we'll be all right. Why? Because I appreciate you sticking with us. We'll keep you informed.